She called me trash on a Tuesday morning, while standing on land my family had owned since 1951. I remember the exact quality of light that morning, the way early October sun came through the ponderosa pines at a low angle and laid long shadows across the gravel driveway. And I remember thinking that my grandfather had watched that same light through those same trees for 50 years, and that the woman in the white Range Rover who had just rolled down her window to tell me I was an eyesore and a disgrace to the community had absolutely no idea what she was standing on. I did not know it yet either, not fully. But I was about to find out, in a way that would change everything about how I understood my family's history, and everything about how Sandra Mercer understood hers. My name is Nate Holloway. 3 weeks before that Tuesday morning, I had been working a service bay at an auto repair shop in Dayton, Ohio, the kind of shop where the fluorescent lights flicker and the coffee is always burnt, and the work is honest, in the specific way that work is honest, when it leaves marks on your hands that soap does not entirely remove. I had $412 in my checking account, 2 months behind on my apartment rent, and a phone call from a county attorney in Colorado informing me that my grandfather Walter Holloway had passed away at 81, and that I was the sole named beneficiary of his estate. My father had told me for as long as I could remember that Grandpa Walter had made a catastrophic financial decision in the early 1950s, sinking everything the family had into 1,000 acres of mountain land in Colorado that was worth nothing because it was nothing, just pine trees and elk trails and altitude, when any sensible person could see that the real money was in urban development and commercial property. The story had been repeated at every family gathering I could remember, always with the same conclusion. Walter was a dreamer, who thought owning wilderness was the same as owning wealth, and the family had spent 3 generations paying for his romanticism. I had grown up understanding myself to be the grandson of a man who had made the family poor through stubbornness and poor judgment. What I had not grown up understanding was that the story I had been told was not the complete story. The drive from Dayton took 11 hours. I made it in one stretch on coffee and the particular focused energy that comes from not having enough money to stop for a real meal and not wanting to spend the night in a motel. I pulled into the driveway of my grandfather's cabin just after 7 in the evening, when the mountain dark was coming down fast, and the temperature had dropped 30 degrees from what I had left in Ohio. The cabin was smaller than I remembered from the one visit I had made as a child, maybe 8 years old, before my father had cut off contact with Walter over some argument whose details had never been explained to me clearly. Cedar log construction, a covered porch running the full front length, a wood stove visible through the window, and surrounding it on every side, the kind of mountain silence that you cannot approximate anywhere else, because it is not actually silence, but rather the complete absence of human noise, which is a different thing entirely. I sat on the porch steps that first evening, and looked out at the tree line, and breathed the air, and tried to understand what I was inheriting. The answer, I believed at that point, was a small cabin on some acres of mountain land that I would sell as quickly as possible to cover the funeral costs and catch up on my rent. I was wrong about that, in ways that would take me several days to fully comprehend. The cabin interior smelled like my grandfather, in a way that was immediately and unexpectedly affecting. Old leather and wood smoke, and pine resin, and something underneath all of that, which I could not name, but which my body recognized before my mind did, as the smell of a person who had lived with intention in a specific place for a very long time. His reading glasses were on the kitchen table next to a coffee mug that had not been washed. Surveying maps covered one wall, hand-drawn in the careful, precise draftsmanship of someone who had spent a professional lifetime making marks that needed to be exactly right. His journals filled 2 shelves in the small back room he had used as an office, 40 years of them, each one dated on the spine in his neat handwriting. I did not read them that first night. I made coffee, ate the last of the crackers I had brought from Ohio, and slept on the couch under a wool blanket that smelled like cedar. The next morning I walked the property, or tried to. Within 100 yards of the cabin in the direction of the northern boundary, I encountered something I had not expected. A subdivision, not a small cluster of vacation cabins, or a modest rural development, but a full-scale residential community, of what appeared to be several hundred homes, the kind of houses that real estate listings described as luxury mountain retreats, with stone facades and 3-car garages, and professionally landscaped lots, carved out of what should have been, according to the boundary markers I was looking at, my grandfather's land. I stood at the edge of the development and looked at it for a long time. The morning was clear and cold, and the houses caught the early light in the way expensive houses are designed to catch it. Summit Crest Estates, read the stone entrance sign, with an HOA crest and what appeared to be a management office address below it. I counted the roof lines I could see from where I was standing. There were more than I could easily count. I went back to the cabin and found the surveying maps on the wall and spent an hour tracing boundaries with my finger and comparing what the maps showed to what I had just seen. Then I started reading my grandfather's journals, not from the beginning, from the most recent entries, working backward. What I found in the first journal I opened, the one covering the past 3 years of his life, was written in the slightly unsteady handwriting of an old man whose hands were not entirely reliable anymore, but whose mind remained precise and organized. He had been documenting something, carefully, methodically, with the professional habit of a man who had spent his career making records that needed to hold up under scrutiny. Dates, names, dollar amounts, legal references, a timeline going back 15 years that described, in the careful neutral language of someone recording facts rather than expressing emotion, exactly what had been done to him and to the land and to the money that should have been his. I read for 4 hours without stopping. When I finished, I sat at the kitchen table and looked at my grandfather's coffee mug and understood for the first time that the story my father had told about Walter Holloway making the family poor was not just incomplete, it was the story that someone else had needed my family to believe in order to keep doing what they were doing without interference. Sandra Mercer arrived at 11:45 that morning, while I was on the porch, trying to process everything I had read. I heard the Range Rover before I saw it, the particular sound of an expensive engine on gravel, and then the vehicle appeared at the end of the driveway and parked with the precision of someone who was accustomed to arriving at places and having the arrival mean something. She was in her mid-50s, dressed in the specific way that communicates money, that has been held long enough to feel like identity rather than acquisition. Blonde hair maintained at significant expense, sunglasses that cost more than my monthly rent had been, a clipboard that she carried the way some people carry authority. She got out of the Range Rover without hurrying and walked toward the porch, with the ease of someone who had never once approached a situation, expecting to encounter resistance she could not manage. I was still wearing the clothes I had driven in, oil-stained work jeans and a flannel shirt with a fraying collar, and I watched her take me in from behind those sunglasses with the specific efficiency of someone filing a person under a category before they have said a word. "Excuse me," she called from the bottom of the porch steps. "Are you the caretaker?" I told her I was the property owner. The category she had filed me under did not visibly update. She introduced herself as Sandra Mercer, president of the Summit Crest Estates Homeowners Association, and informed me that the vehicle in my driveway, my 12-year-old work truck, was in violation of community standards regarding commercial vehicle storage in residential areas, and that I had 72 hours to relocate it or face a daily fine of $500. I told her the vehicle was on private property and that I was not a member of the Homeowners Association. Her smile adjusted by a fraction that communicated patience with people who did not yet understand how things worked. "Mr. Holloway," she said, "every property owner in this area is subject to community standards. It is not optional." I told her again that I was not a member of any homeowners association and had not signed any covenant or agreement requiring compliance with community standards. She told me I was mistaken and that perhaps I did not fully understand the legal framework governing the area. I told her I was beginning to understand it rather well. Her expression shifted then into something underneath the professional surface of the HOA president performance, something with less patience and more edge. She looked at my truck, at my clothes, at the cabin behind me, and she said something that I have thought about many times since, because of what it revealed about how she understood the situation, and how completely that understanding was about to be proven wrong. She said, "Honey, people like you don't belong on mountains like this. Find somewhere more suitable." Then she got back in her Range Rover and drove away. I stood on the porch of my grandfather's cabin and watched the Range Rover disappear down the mountain road, and felt something settle in my chest that was not anger exactly. Though anger was part of it. It was more like clarity, the kind that arrives when you finally have enough information to see the full shape of something that has been partially obscured for a long time. I went back inside and called a property attorney. Claire Ashton had an office in Denver and a reputation, according to the review I found while standing in my grandfather's kitchen, for property dispute cases that larger firms declined because they were too complicated or too contentious, or both. She answered her own phone, which I took as a good sign. I spent 20 minutes telling her what I had found in the journals, and what I had seen on the property, and what Sandra Mercer had said to me on the porch. Claire was quiet through most of it. When I finished, she asked me 3 questions. Did I have the original 1951 land purchase documentation? Did the journals include specific financial records with dates and amounts? And had I found anything in the cabin's papers relating to a lease agreement? I told her the purchase documentation was in a fireproof box under the desk in the back office. I told her the journals had 15 years of detailed financial records. And I told her that I had found, in the same fireproof box as the purchase documentation, a document I did not fully understand, but that appeared to be a 99-year land lease agreement bearing a date in the 1950s, and a clause near the end that Grandpa Walter had underlined in red ink and annotated in the margin with a single word. Important. Claire was quiet for a moment after I described the clause. Then she said she needed to see everything in person and asked if she could drive up the following morning. She arrived at 8 and spent 3 hours at my grandfather's kitchen table with the documents spread around her, reading carefully and making notes in the precise economical handwriting of someone who had learned to capture exactly what mattered and nothing else. I made coffee and stayed out of her way, and watched the mountain light move across the surveying maps on the wall, and thought about my grandfather sitting in this same kitchen for 50 years, watching the same light, and knowing what he knew, and writing it all down in journals that nobody read until now. Claire finally looked up from the documents. She had the expression of someone who has been doing demanding work for a long time and has just encountered something that reminds them why they chose it. "Nate," she said, "I need you to understand what you have here before we talk about what comes next. Because what you have here is not a simple inheritance dispute." She started with the land itself. Walter Holloway had purchased 1,340 acres of mountain land in 1951 for $3,100, which had seemed like a poor investment to everyone who knew him at the time, because it was raw wilderness, with no infrastructure and no obvious development potential. What they had not appreciated, because Walter had not told them, was that he had spent years as a county surveyor studying the land and understood something about its location and its water rights and its access road geometry that nobody else had connected yet. He had bought it knowing what it would eventually be worth. He had simply not lived to see the appreciation reach its full extent. Or rather, he had lived to see it, but had not lived to benefit from it in the way he should have. In the early 1960s, a development company had approached Walter about leasing a portion of the land for residential development. The lease agreement they had negotiated gave the developer rights to build on approximately 900 acres of the property, in exchange for monthly lease payments indexed to the number of residential units developed. At full build-out, which had been achieved by the mid-2000s, those payments should have amounted to just over $14,000 monthly. The lease had a term of 99 years from the signing date, meaning it would not expire until well into the next century. But it also contained the clause that Walter had underlined in red, the reversion clause. Claire explained it carefully. Under Colorado property law, when a long-term land lease contains a reversion clause, and the lease payments are interrupted or diverted without the landowner's consent for a period exceeding 90 days, all improvements constructed on the leased land revert to the ownership of the landowner. The clause had been included at Walter's insistence during the original negotiation, over the objection of the developer's attorneys, because Walter had understood that a 99-year lease, without a reversion provision, gave the lessee too much protection against bad faith conduct. He had been right to insist on it, because beginning approximately 15 years ago, the lease payments that should have been going to Walter Holloway had stopped reaching him. Not stopped being collected, stopped reaching him. The property management company that had taken over administration of Summit Crest Estates had been collecting the lease payments from homeowners as part of their monthly HOA fees, had been processing them through the management accounts, and had been distributing them to an entity that was not Walter Holloway and was not any legal successor to his interests. Claire pulled out a single page from the stack of documents and set it in front of me. The property management company that has been administering Summit Crest Estates for the past 15 years, she said, is registered to a Richard Mercer. I looked at the page. Richard Mercer, husband of Sandra Mercer, HOA president of Summit Crest Estates. The woman who had stood on my grandfather's porch that morning and told me that people like me did not belong on mountains like this, had been living in a house built on my family's land, collecting my family's lease payments through her husband's management company, and had been doing so for 15 years, while my grandfather died, believing the family had been cheated out of everything. I sat with that for a long time. Claire let me. Outside the cabin window, the mountain was doing what mountains do in October, cycling through light and shadow as clouds moved over the ridge, indifferent to everything happening below. What does the reversion clause actually mean? I asked. In practical terms. Claire folded her hands on the table. It means, she said carefully, that because the lease payments have been diverted, rather than paid to the lawful landowner, for a period far exceeding 90 days, all improvements constructed on your grandfather's land, under that lease agreement, have legally reverted to the landowner. I looked at her. Which is now me. Which is now you. How many homes are we talking about? Claire consulted her notes. Based on the development records and the HOA membership figures in your grandfather's documentation, she said, 861 residential units. I did the math slowly. Average property value in a mountain luxury subdivision outside of Colorado City. $450,000 per unit on the conservative end, 861 units. I stopped doing the math because the number I was arriving at was large enough to feel unreal. Claire watched me work through it. The total estimated value of the improvements that have legally reverted to your ownership, she said, is approximately $387 million. The cabin was very quiet. The wood stove ticked as the metal contracted in the cooling morning. I looked at my grandfather's coffee mug, still on the table where he had left it, and thought about a man who had bought this land, because he understood something about it that nobody else could see, who had watched it become exactly what he had known it would become, and who had spent his last years writing careful records in journals that nobody read, because the people closest to him had been told a story about him that was designed to keep them away. Then I looked out the window at the ridgeline where Summit Crest Estates sat in the afternoon light. 861 houses on land that had belonged to my family for 70 years. And I thought about Sandra Mercer on my porch that morning, in her sunglasses and her expensive clothes, telling me that people like me did not belong here. I picked up my coffee and drank it, and set it down next to my grandfather's mug. Claire was watching me with the patient attention of someone waiting for a decision. I asked her what the first step was. She told me we needed to file a quiet title action immediately, before anyone connected to the Mercer operation could move assets or alter records. She also told me that what she had found in the financial documents suggested conduct that went beyond civil fraud into criminal territory, and that she had a contact at the FBI white-collar unit she was going to call before she drove back to Denver. I told her to make the call. Then I went out to the porch and sat in my grandfather's chair and looked at the mountain and the subdivision on it and started making a list of everything I was going to need to understand before this was over. The list was long. The mountain was patient. And Sandra Mercer, somewhere in one of those 861 houses built on land she did not own, had absolutely no idea that the mechanic from Ohio she had called trash that morning was about to become the most significant legal problem of her life. Claire called her FBI contact from my driveway before she finished loading the document copies into her car. I could hear fragments of the conversation through the open cabin window while I made a second pot of coffee. Enough to understand that whatever she was describing was landing with the kind of weight that produces immediate professional attention rather than the polite acknowledgement and delayed follow-up that most referrals generate. She came back inside with the focused energy of someone who has just confirmed that a situation is larger than the original assessment suggested. Agent Dana Fields is driving up from Denver tomorrow morning, she said. She has been tracking a pattern of HOA financial fraud across 3 Colorado counties for the past 2 years. And some of what your grandfather documented matches the signature elements of what her unit has been building toward. I asked Claire how long she thought the full legal process would take. She was honest about it the way good attorneys are honest, when the answer is not what the client wants to hear. The quiet title action alone could take 6 to 8 months if it is contested, she said. And it will be contested. The Mercers have too much at stake to let this resolve quietly. But there are interim measures we can file immediately that will freeze their ability to move assets or alter records, while the main action proceeds. She paused. There is also the question of how you want to handle the homeowners, the 861 families who own houses in Summit Crest Estates, and who have been paying their HOA fees and their lease assessments every month in good faith for years, not knowing that the money was going to Richard Mercer's management company, instead of to your grandfather. Most of them had nothing to do with what was done to Walter Holloway. They bought homes through standard real estate transactions and signed documents that described their lease obligations and paid what they were told to pay. The fraud had been committed against them as much as against my grandfather, in the sense that they were paying for something they were not receiving, which was a legitimate lease arrangement with the actual landowner. I told Claire that protecting those families was not negotiable. Whatever legal strategy we pursued had to be built around a path that allowed innocent homeowners to keep their homes on fair terms. She nodded, as if she had expected this answer, and had already begun structuring the approach around it. She left me with instructions to touch nothing, alter nothing, and speak to no one connected to Summit Crest Estates until after her filing the following morning. Then she drove back down the mountain, and I was alone in my grandfather's cabin, with the journals and the maps and the wood stove, and the particular silence of a place that had been carrying a secret for 15 years, and had finally found someone to tell it to. I spent that evening reading, not the recent journals this time, but the older ones, going back to the years before the fraud had begun, back to the period when Walter had been managing the lease legitimately and watching the subdivision develop on land he had bought for $3,100 when everyone around him thought he was wasting the family's money. His writing in those years had a different quality than the careful documentary tone of the later entries. It was more personal, more reflective, the writing of someone working through ideas rather than recording evidence. He wrote about the land, the way people write about things they understand from the inside, not as acreage and boundary lines, but as a living system with its own logic and its own patience. He wrote about watching the first houses go up in the early 1960s, and feeling the complicated satisfaction of seeing something he had believed in before anyone else believed in it become real. He wrote about the lease payments arriving each month, and what it meant to have been right about something everyone had told him was a mistake. And he wrote, in an entry dated about 16 years ago, about a new property management company that had taken over administration of Summit Crest Estates, and about the man who ran it, Richard Mercer, who had come to the cabin to introduce himself, and had been polite and professional, and had explained the transition in terms that sounded entirely reasonable, and had left Walter with paperwork that he had signed, without fully understanding that the payment routing it established would redirect his lease income to an account he did not control. That entry was the last one, with the easy, reflective quality of the earlier writing. Everything after it was documentation. I closed the journal and sat with the wood stove for a while. My grandfather had not been foolish. He had been trusting, which is a different thing, and he had been old and alone, and dealing with a man who was experienced at presenting fraudulent arrangements in language that sounded legitimate. The family story about Walter making poor choices with money was not just incomplete, it was a deliberate inversion of what had actually happened, and I found myself wondering how much of my father's distance from Walter in those final years had been shaped by a narrative the Mercers had actively encouraged. Agent Dana Fields arrived at 7:30 the next morning, in a gray sedan that was not trying to look like anything other than a government vehicle. She was in her early 40s, with the specific economy of movement of someone who had spent years doing work that required her to be accurate and efficient simultaneously. She shook my hand, accepted coffee, and spent the first hour reading, rather than talking, working through the documentary evidence Claire had organized, with the focused absorption of someone who reads professional material, the way other people read things they are genuinely interested in. When she looked up, she had the quality of attention that I had noticed in Claire the day before. The specific alertness of someone encountering confirmation of something they had been working toward for a long time. "Mr. Holloway," she said, "what you have in these journals matches the operational signature of a fraud scheme we have been tracking in 3 counties. Same structure every time. Legitimate property management company takes over HOA administration. Payment routing gets altered during transition paperwork. Landowner or legitimate fee recipient gradually stops receiving funds and is managed through a combination of false accounting, legal intimidation, and deliberate isolation from anyone who might help them understand what is happening." She set down her coffee. "In your grandfather's case, the isolation element was particularly effective because it happened at the family level. Whoever structured this understood that an elderly man whose family believed he was financially incompetent would not have credible advocates pushing back on the management company's version of events. I thought about my father repeating the story of Walter's poor choices at every family gathering. I thought about how thoroughly I had absorbed that story as a child, and how completely it had shaped my understanding of my grandfather. Then I thought about Walter sitting in this cabin for 15 years, watching his lease income disappear, trying to document what was happening to him, writing careful records in journals nobody read, because the people who might have helped had been told not to trust his judgment. "We are going to need access to the management company's financial records," Fields said. "The court filing Claire is processing this morning will trigger a discovery order that covers those records. But I want you to understand that this process has a federal dimension that extends beyond your civil claim. The Mercers have been moving money through multiple entities across state lines. That is wire fraud at minimum, and potentially money laundering depending on what the financial forensics show. The investigation is going to be thorough, and it is going to take time." She looked at me directly. "In the meantime, they are going to know that something has changed. The filing will be public record, and the Mercers have resources and connections that they will deploy to protect their position. I need you to be prepared for escalation." The escalation began the following morning, before I had finished my first cup of coffee. Sandra Mercer's Range Rover appeared in my driveway at 7:15, accompanied by a black Mercedes that disgorged 2 men in expensive suits, carrying briefcases, with the coordinated efficiency of people who practiced arriving in ways that were meant to establish dominance before a word was spoken. Sandra herself had abandoned the previous morning's performance of polite community standards enforcement. She was operating in a different register now, the register of someone who has received information overnight that has changed their understanding of the situation, and who has decided that the appropriate response is direct and immediate pressure. "Mr. Holloway," she said from the bottom of the porch steps, "I understand there has been a legal filing this morning regarding my family's property management operations. I need you to understand something clearly. My husband has managed Summit Crest Estates for 15 years, and has done so with the full knowledge and cooperation of your grandfather, who was compensated fairly throughout that period. Whatever you think you found in those papers does not reflect the complete picture." I told her that my attorney was handling all communications, and that she should direct any correspondence to Claire Ashton's office in Denver. The man on Sandra's left, who introduced himself as Marcus Webb from a Denver law firm, stepped forward with the confident smoothness of someone who had conducted this kind of intervention many times. "Mr. Holloway," he said, "my clients are prepared to resolve this matter quickly and privately. We understand you are in a difficult financial situation, and that you came here expecting a modest inheritance. We are prepared to offer you $800,000 for a complete transfer of any claims arising from the 1951 land purchase, including all documentation currently in your possession. $800,000 against $387 million in reversion value. Either Webb had not done the math, or he was testing how much I understood about what I had. I told him the answer was no, and that all future communications should go to Claire Ashton. He started to say something else, and I went back inside and closed the door. Through the window I watched Sandra and her attorneys stand in the driveway for a moment, recalibrating, before getting back in their vehicles and driving away. I called Claire immediately. She already knew about the offer, because Webb had called her office that morning before coming to the cabin, which told me the Mercers were trying to work both ends of the communication chain simultaneously. She told me not to worry about it, and that the filing had been accepted by the court, and that the discovery order covering the management company's financial records was already in motion. Then she told me something else. During the initial records review her office had conducted the previous day, she had found something in the county assessor's filings that added a layer to the situation. The assessed value of my grandfather's land had been systematically reduced over the past 12 years, from its legitimate market valuation to a figure that was approximately 1/8 of the correct amount. The signature on every reassessment was Richard Mercer, who held a position with the county assessor's office. He had been using an official government role to artificially suppress the taxable value of land his wife's management company was fraudulently administering, which kept the property tax burden on Walter low enough that he had never had grounds to challenge the assessments, while simultaneously keeping the documented value of the land low enough that anyone reviewing public records would not understand what the Mercers were actually sitting on. That is a separate criminal exposure from the lease payment diversion, Claire said. Using a government position to manipulate official records constitutes fraud against the county, as well as against your grandfather. I forwarded everything to Agent Fields this morning. I spent that afternoon at the county library, which was a small building on the main street of the nearest town, staffed by a woman named Mrs. Ruth Henley, who had silver hair and reading glasses, and the specific institutional memory of someone who had been in the same building long enough to know where everything was, including the things that were not in the catalog. She recognized my grandfather's name before I introduced myself. "You are Walter's grandson," she said. "He used to come in every few weeks right up until the last couple of years, when he stopped getting around as well. Brought me elk jerky every fall." I told her what I was looking for, the history of Summit Crest Estates, and any public records related to the original development and the property management transition. She led me to the county records section, with the quiet efficiency of someone navigating familiar terrain, and spent 20 minutes pulling folders that she clearly knew by location rather than by catalog number. What we found in those folders took an hour to work through, and left me standing at the records table with the particular feeling that comes when a picture you thought you understood reveals itself to have been showing you only part of the image. The original development company that had built Summit Crest Estates in the 1960s had been legitimate. The lease payments during that period had been properly processed and delivered to Walter. The fraud had begun precisely when Richard Mercer's management company took over administration, and it had been structured from the beginning, with a sophistication that suggested it had been planned rather than improvised. The transition documents included a payment routing authorization that Walter had signed, but the version on file in the county records was different in a specific technical detail from the version in Walter's papers. The account number designated for lease payment deposits had been altered. The copy Walter had signed directed payments to his account. The copy in the county records directed payments to an account belonging to Mercer Property Solutions LLC. Someone had filed an altered document with the county and kept the original to prevent Walter from immediately detecting the discrepancy. Mrs. Henley looked at the two documents side by side with the careful attention of someone who had spent decades handling documents and understood what she was seeing. "That is not a clerical error," she said quietly. She pulled out her phone and took photographs of both documents before I could ask her to. "I was friends with your grandfather for 20 years, she said. "He was a good man, and he knew something was wrong, but he could not get anyone to listen to him. I am glad you are here. Dorothy Payne found me outside the library as I was getting into my truck. She was a retired schoolteacher who lived 2 streets into the subdivision and who had apparently been watching the situation develop with the attentive concern of someone who had noticed things that she had not known what to do with until now. "Mr. Holloway," she said, "I heard you were in town asking questions about the development history. I think there are some things you should know about what has been happening inside Summit Crest Estates that do not show up in any county record." We sat in the library parking lot for 40 minutes, while Dorothy described the internal climate of Summit Crest Estates under Sandra Mercer's HOA presidency. The special assessments that appeared in residents' monthly bills without explanation or community vote. The security fees that Sandra had introduced 18 months ago that were supposed to fund a neighborhood patrol service that nobody had ever seen operating. The way residents who asked questions at HOA meetings found themselves suddenly facing building code inspections that produced violations requiring expensive remediation. The way Sandra's husband Richard appeared to have access to county enforcement mechanisms that he deployed against people who created friction for the HOA administration. and the way the financial statements that Sandra presented at the annual HOA meeting never quite matched the fee calculations that residents could do for themselves if they added up their monthly bills and multiplied by the number of homes. "She's been charging us for things that don't exist and keeping the difference," Dorothy said. "Most people know something is wrong, but nobody has been able to get documentation because she controls the HOA records and won't release them to residents who request them." I told Dorothy that documentation was coming, and that when it arrived it was going to be thorough. She looked at me for a moment, with the evaluating attention of a former teacher, assessing whether a student understands what they have just been told. Then she said she had neighbors who had been collecting their own records for months, bills and assessment notices and meeting minutes, and that if it would help, she could have those materials to me by the following morning. I told her it would help considerably. Earl Sutton was waiting on my cabin porch when I got back from town. He ran the hardware store on Main Street and had the weathered hands and direct manner of a man who had been doing physical work in the same place for a long time and had developed a clear-eyed understanding of how things worked in the community around him. He had heard from Dorothy that Walter Holloway's grandson was in town, asking questions, and he had decided to come up and say something directly, rather than wait for the situation to find him. "Son," he said, settling into the porch chair, the way someone settles into a chair they have sat in before, which told me he had known my grandfather well enough to visit. "That woman has been running a protection operation against every business on Main Street for 3 years. Monthly donations to the HOA Community Development Fund that she makes clear are not optional. Anyone who does not pay ends up with county inspector visits that produce violations that happen to require remediation work done by contractors who have a relationship with Richard Mercer's office. My store got hit twice. I asked him how many businesses were involved. He thought about it. Every business on the main commercial block, he said. 12 at minimum. Maybe 15 if you count the ones that paid quietly to avoid the trouble." He reached into his jacket pocket and produced a folder. "I have been keeping records since the second time it happened to me. Dates, amounts, the inspector's name, the contractor who showed up afterward. I did not know what to do with it until now. I took the folder and added it to the stack of documentation that was building on my grandfather's kitchen table. The Mercer operation was considerably larger than a diverted lease payment scheme. It was a coordinated extraction system running through every financial channel available to people with HOA authority and county government connections. And it had been operating for long enough that it had become the background condition of the entire community. The water that everyone swam in without quite being able to describe what was wrong with it. That evening, I called Claire, and then Agent Fields, and walked both of them through what I had found in the county records and what Dorothy and Earl had told me. Fields was quiet while I talked, and then asked 2 precise questions about the altered payment routing document and the contractor relationship between the county inspector and Richard Mercer's office. The first question told me she already had the altered document in her evidentiary framework. The second question told me the contractor relationship was a thread she had been following in one of the other county investigations and had not yet connected to the Summit Crest situation. I heard her writing, and then she said something that told me the federal dimension of the case had just expanded significantly. "Mr. Holloway," she said, "I need to move the timeline up on this. What you have described today connects elements across 3 separate county investigations in a way that establishes the kind of organized pattern that justifies a coordinated federal response rather than a series of individual local cases. I am going to need everything on your grandfather's table scanned and uploaded to a secure server by tomorrow morning. Can you do that?" I told her I could. I spent 4 hours that night at the scanner I had driven into town to buy at Earl's hardware store, working through journals and lease documents and county records copies, and Dorothy's neighbor documentation, and Earl's business records, uploading everything to the secure server Fields had set up, and watching the file sizes accumulate into a body of evidence that represented 15 years of one old man's careful record-keeping, finally being read by people with the authority and the tools to do something with it. Around midnight I stopped for coffee and stood at the kitchen window and looked out at the mountain. The lights of Summit Crest Estates were visible through the trees, 861 houses glowing against the dark, each one occupied by a family who had no idea that the ground under their home was about to shift in ways they had not anticipated. I thought about how to handle what was coming for those families. the innocent ones who had bought in good faith and paid their fees, and had no part in what the Mercers had done. The reversion clause gave me a legal instrument of enormous power. It could be used to displace nearly 1,000 families from their homes, or it could be used as leverage to build something better than what the Mercers had created. My grandfather had written in one of his last journal entries that the land was supposed to be for families. That was why he had agreed to the lease in the first place, because he had believed that mountain land at the right price could give working families access to something they would not otherwise be able to afford. The Mercers had turned that into an extraction operation. I was going to turn it back into what Walter had intended, but first, I needed to understand the full scope of what I was dealing with, and the full scope was still revealing itself. Sandra Mercer's next move came at 2 in the morning, and it was not a phone call or a legal filing. It was a truck backing onto my property in the dark, and what it was carrying told me that the Mercers had moved from legal pressure into something that required a different kind of response entirely. The truck was a heavy-duty flatbed with a hydraulic dump mechanism and no identifying markings on the doors, which told me it had been chosen specifically for this purpose rather than pulled from a regular fleet. The trail cameras I had installed along the north boundary 2 days after arriving caught it clearly. Infrared footage showing the vehicle backing through the gap in the fence line that connected my property to the access road, servicing the subdivision's maintenance entrance. 2 men in dark clothing unloaded equipment with the practiced efficiency of people doing something they had done before and wanted to finish quickly. Broken concrete sections, construction debris, old roofing material with rusted fasteners still attached. They were dumping it across the meadow at the northern edge of my property, the open ground that sat closest to the subdivision boundary, and they were doing it in a pattern that was not random, targeting the area around my main well access and the drainage channel that fed the lower pasture. I watched it on the camera feed on my laptop from inside the cabin and understood immediately what the operation was designed to accomplish. Contaminated ground near a water source created the predicate for an environmental compliance complaint. Environmental compliance complaints, especially ones involving potential groundwater issues, could trigger regulatory intervention that was difficult and expensive to contest, regardless of who was actually responsible for the contamination. The Mercers were trying to manufacture a legal lever they could use to offset the quiet title action and the discovery order in a different regulatory arena, one where Richard Mercer's county connections might still be operational. I called Agent Fields on her direct number. She answered on the second ring despite the hour, which told me she had been expecting contact. I described what the cameras were showing. She told me not to approach the individuals, not to touch anything they left behind, and to make sure the footage was being captured to the cloud backup simultaneously with local storage. Then she said she was making 2 calls, and that I should expect official presence at my property before sunrise. She was right about the timeline. 2 county sheriff's vehicles came through my main gate at 4:40 in the morning, followed by a state environmental agency truck whose presence I understood. Fields had arranged through channels that bypassed Richard Mercer's county assessor connections entirely. The deputies documented the dumped material, while the environmental officer collected samples and photographed the disposal pattern. One of the deputies, a younger man named Briggs, who seemed to be making careful note of everything, in a way that suggested he was building his own record rather than simply processing a call, asked me how long the cameras had been operational. I told him since the second day after I arrived. He asked if the dump truck was on footage approaching the property. I showed him the full sequence on my laptop, from the truck's arrival at the access road to the completion of the dump and departure. The footage included a clear shot of the truck's front plate as it turned under the infrared camera, covering the fence gap. Briggs photographed the laptop screen and then asked me to preserve the original files. I told him they were already uploaded to a federal evidence server. His expression when I said federal evidence server was the specific expression of a local law enforcement officer recalibrating the nature of the situation he has just walked into at 5 in the morning. The material dumped on my property was traced to a demolition contractor operating out of a commercial district 2 counties away. The contractor's billing records, obtained through the discovery order that was already in motion from the quiet title action, showed a payment from Mercer Property Solutions LLC 3 days before the dump. That payment became Exhibit 47 in what Agent Fields described to Claire during a call I was copied on later that week as a federal obstruction case that was developing in parallel with the wire fraud and money laundering investigation. Sandra Mercer apparently did not understand that every action she took to protect her position after the quiet title filing was being observed, documented, and added to a federal case file by people who had been building toward exactly this kind of coordinated criminal exposure for 2 years before I arrived in Colorado. The quiet title hearing was scheduled for 6 weeks after Claire's initial filing. In the intervening period, the situation in Summit Crest Estates developed the particular internal pressure that builds in communities when people who have been separately suspicious of the same things start talking to each other openly for the first time. Dorothy Payne was the catalyst for most of it. She had the natural organizing instincts of a former teacher and the community trust of someone who had lived in the neighborhood for 11 years without ever participating in Sandra's enforcement operations. And she used both to facilitate the kind of honest conversations among residents that Sandra's HOA structure had been specifically designed to prevent. I attended 2 of the informal meetings Dorothy organized in her living room, sitting in the corner and listening while residents described their individual experiences with the assessment irregularities and the code inspection pattern and the security fee that had been collecting for 18 months without any visible security service to show for it. What struck me was how many people had been carrying the same specific suspicions in isolation, each one assuming they were alone in noticing something that did not add up, each one deterred from speaking up by the reasonable fear that raising questions about Sandra Mercer's administration would result in the targeted attention that everyone had watched happen to others. Dorothy's meetings broke the isolation, and what emerged from them was not the anger I might have expected, but something more like the relieved recognition of people who have been told for years that what they are seeing is not real, and have just been confirmed that it is. They also produced documentation that Claire described as some of the most useful supporting evidence in the quiet title file. Resident records covering the gap between what the HOA bylaws authorized and what Sandra had actually been collecting, organized by Dorothy with the methodical precision of someone who had spent 30 years teaching students how to build an argument from evidence. Richard Mercer resigned from the county assessor's office 8 days before the quiet title hearing. The resignation came the morning after Agent Fields executed search warrants on both the Mercer Property Solutions offices and the Mercer family residence, and it was accompanied by a statement from his attorney that said only that he was stepping down to focus on personal matters and that he denied any wrongdoing. The denial lasted 4 days before his attorney contacted the federal prosecutor's office to discuss cooperation terms. What Richard Mercer provided, in exchange for a reduced charge recommendation, was a complete account of the operation from its beginning, including the deliberate alteration of the payment routing document that Walter had signed, the mechanism by which the county assessment records had been manipulated, the distribution of funds through the multiple shell entities that Fields had been tracing across 3 counties, and the identity of 2 other property owners in different Colorado communities who had been subjected to variations of the same scheme. His cooperation also confirmed something I had suspected from the journals, but had not been able to document directly. The narrative about Walter Holloway being financially incompetent had been actively cultivated. Richard Mercer had been the source of information, passed through intermediaries to members of my family, that Walter was confused about his finances and making poor decisions. The isolation had been engineered. My grandfather had not been abandoned by a family that did not trust him. He had been separated from a family that had been given reasons not to trust him, by the same people who were stealing from him. I sat with that for a long time after Claire called me with the summary of Richard's cooperation statement. The cabin was quiet in the particular way it got in the evenings when the wind dropped and the temperature fell, and everything outside went still. I thought about my father repeating the story of Walter's poor choices. I thought about the distance between them in those final years, and what it had cost both of them. I thought about Walter writing in his journals, documenting everything carefully, holding on to the evidence in a fireproof box, waiting for someone to come and read it. He had known the family was staying away because of what they had been told. He had written about it once, in an entry I had found near the middle of the third-to-last journal, in a passage that was more personal than most of his writing in that period. He said he hoped that whoever eventually found the records would understand that he had not given up and had not stopped believing that it would be made right. He said the land was still there, and it would still be there, and that was enough. The quiet title hearing lasted 1 day. Sandra Mercer's legal team had filed 3 separate motions to delay or dismiss in the weeks preceding it, all of which had been denied. They appeared at the hearing with a team of 4 attorneys and a stack of documents that included the altered payment routing authorization, which they presented as evidence that Walter had consented to the payment arrangement. Claire presented the original document from Walter's fireproof box, alongside the county records copy, and a forensic analysis confirming the account number alteration. She also presented Richard Mercer's cooperation statement, which the court admitted over the objection of Sandra's lead attorney, on the grounds that it constituted an admission by a party with direct knowledge of the transaction. The judge presiding over the quiet title action was a woman named Patricia Okafor, who had the quality of someone who had reviewed every document submitted in advance and arrived in the courtroom with formed views that she was testing rather than forming. She asked Claire 3 questions, and Sandra's lead attorney 7 questions, and the distribution of those questions told me everything about where the hearing was going before she delivered her ruling. The ruling came at 4:30 in the afternoon. Judge Okafor found in favor of the plaintiff on every element of the quiet title claim. She confirmed the Holloway family's continuous ownership of the 1,340 acres from the 1951 purchase through the present. She found that the payment routing alteration constituted fraudulent inducement that voided the legitimacy of the management transition. She found that the systematic diversion of lease payments for a period exceeding 15 years triggered the reversion clause in the original 1951 lease agreement, and that all improvements constructed on the leased land under that agreement had legally reverted to the landowner. She issued an immediate injunction freezing all Mercer Property Solutions accounts and prohibiting any further collection of fees from Summit Crest Estates residents, pending full financial accounting. And she ordered the production of complete financial records from every entity connected to the management operation within 30 days. Sandra Mercer did not speak during the ruling. She sat at the defense table in the clothes she had worn to the hearing, which were the same kind of expensive and carefully selected clothes she had been wearing every time I had seen her, and she looked straight ahead with the particular blankness of someone whose processing capacity has been fully consumed by the gap between where they expected to be and where they actually are. Her attorneys were already in motion before the judge finished, consulting in low voices, making notes, planning the appeal that everyone in the room understood was coming, and that everyone in the room also understood was not going to change the fundamental outcome. The federal charges came down 3 weeks after the quiet title ruling. Wire fraud, money laundering, conspiracy to commit fraud, obstruction of justice in connection with the dump operation, and 2 counts of filing fraudulent documents with a government agency. Richard Mercer's cooperation reduced his exposure to a single count of wire fraud with an agreed sentencing recommendation. Sandra faced the full charge list. Her lead attorney negotiated for 6 weeks before she accepted a plea agreement that included 4 years in federal custody, full financial restitution across all documented fraud activity, and permanent prohibition from serving in any property management, HOA governance, or government assessor capacity. The restitution calculation, which Fields' financial forensics team had been building since the first discovery order, came to $2.1 million, covering the diverted lease payments, the fraudulent special assessments, the illegal security fees, and the extortion payments collected from Main Street businesses. The $2.1 million was a fraction of what the Mercer operation had actually extracted over 15 years, across all 3 counties. But it was what could be documented with the precision required for criminal restitution purposes. And it was real money that went to real people who had paid it under false pretenses. The homeowner resolution took longer than the legal proceedings and required more of my attention during the months that followed, because it was not a process that could be handed to attorneys and judges. It required actual conversation with actual people about their actual homes, which meant Dorothy Payne's kitchen table and Earl Sutton's hardware store back room and 100 porch conversations across Summit Crest Estates, with families who had received my letter, explaining the legal situation, and were trying to understand what it meant for them. The letter had taken me a week to write, because I wanted it to be honest, without being frightening, and clear without being clinical. I explained the reversion clause and what it meant legally. I explained that I was not going to use it to displace anyone from their home. I explained that I was offering every household the opportunity to purchase the land under their property at fair value, with a payment structure designed to cost less per month than the combined HOA fees and lease assessments they had been paying to the Mercer operation. And I explained that the new governance structure for Summit Crest Estates was going to be built by residents rather than imposed from above, which meant that the first thing I was going to do was nothing, and the second thing was to listen. 743 households signed purchase agreements within 60 days. The remaining 118 signed within the following 4 months. The delay, in most cases, attributable to the time required to review the terms with personal attorneys and reach the conclusion that the offer was genuinely what it appeared to be, rather than another version of the kind of arrangement they had been living under. The purchase price per lot was set at $55,000, with a 10-year payment plan at 2.5% interest, structured by the financial analyst Claire brought in, to ensure the terms were both fair to residents and sufficient to fund the conservation and infrastructure improvements I had planned for the non-residential portions of the property. Earl Sutton became the first chair of the new resident-governed HOA board, elected by the community with the kind of straightforward democratic process that Summit Crest Estates had never experienced under Sandra's administration. Dorothy Payne joined the board as treasurer and applied the same methodical documentation instincts she had used to help build the legal case to the task of making the financial records genuinely transparent and genuinely public. The monthly fee under the new structure was $62, covering actual common area maintenance and a reserve fund for infrastructure repair, down from the $450 per month that residents had been paying to the Mercer operation for services that had been largely fictional. 400 acres of the property that had never been developed were placed in a permanent conservation easement in partnership with a state land trust, protecting the elk habitat and watershed that Walter had been managing informally for 50 years, and that the development on the northern acreage had been slowly encroaching on. The conservation designation was the piece of the resolution I thought about most in the months after everything settled, because it was the piece that most directly honored what Walter had actually been trying to do when he bought the land in 1951. He had not bought it primarily as an investment, though he understood its investment potential. He had bought it because he believed that wild mountain land had a value that was not captured by any assessment, and that somebody needed to be the person who held on to it. He had held on to it through 50 years of family misunderstanding and 15 years of active fraud, writing careful records in journals nobody read, and keeping the original documents in a fireproof box, and trusting that eventually someone would come and understand what he had been protecting and why. I drove back to Ohio once during the legal proceedings to close out my apartment and collect what I owned, which fit in the bed of my truck with room to spare. On the way back, I stopped at a rest area in Kansas and sat on a picnic table in the cold and called my father. It was the first real conversation we had had in several years, and it was not an easy one, because I had to tell him things about Walter that contradicted a story he had been told so many times it had become part of how he understood his own family history. He was quiet for a long time after I finished. Then he said he was sorry. I told him there was nothing to apologize for, and that the people who owed apologies were going to be paying them in federal court. He laughed at that, a short, surprised sound, and then he was quiet again for a moment. He asked if the cabin was still standing. I told him it was. He asked if it still smelled like pine resin and old leather. I told him it did. He said he might want to come see it sometime. I told him he was welcome anytime. Walter's surveying compass sits on my kitchen table now, next to the coffee mug I still have not washed, next to the journals that I have read completely twice, and that I keep accessible rather than filed away, because they are not just evidence of what was done to him. They are a record of a man who understood something important and held on to it through everything that tried to take it away from him, and I find it useful to have that record nearby, on the mornings when the work of what comes next feels complicated. The mountain is the same mountain it has always been. The elk have come back to the northern meadow now that the access road construction that had been encroaching on their corridor for 3 years has been redirected. The pines along the eastern ridge are growing into spaces that the development had kept clear through maintenance contracts that no longer exist. The land is doing what land does when people stop managing it against its own nature, and start working with it instead. If you are dealing with a property situation that does not make sense, one where the official story and the documents do not align, where the money does not trace to where it should, where people with authority seem unusually motivated to keep you from looking too closely, the first thing to do is find the original documents. Not the current management's version of events. The originals. The ones filed with the county recorder's office. The ones in fireproof boxes under desks. The ones in the careful handwriting of people who understood that records were the difference between being able to prove what happened and being at the mercy of whoever controlled the official version. My grandfather knew that. He spent 15 years proving it, in journals nobody read until it was almost too late. Read the documents. Find the clause nobody told you about. And do not let anyone convince you that you do not belong on land that is yours.